Here's everything you need to know about why Justin Baldoni's lawsuits were tossed straight from the judge's 132-page document. These lawsuits were filed in an amended complaint, and they were submitted by Wayfair Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, who's the money behind everything, Jennifer Abel, who is Justin Baldoni's publicist, and Melissa Nathan, who is the crisis manager. They were going after Blake Lively, her husband Ryan Reynolds, her publicist Leslie Sloan, and the New York Times. Everyone that Justin Baldoni was going after filed a motion to dismiss, and that's what this is. It is the judge responding to their motion to dismiss. So here's what they were asking for. They wanted the motions to be completely dismissed, but they also wanted to move to be awarded attorney fees and costs pursuant to the laws in New York State. Blake Lively was also moving for an award of attorney fees, treble damages, which means 3 times the damages, punitive damages, and that was all according to California civil law. Lively, Sloan, and Reynolds were also moving to strike Exhibit A. Now, Exhibit A was Justin Baldoni's timeline that, if you recall, he uploaded to a website. Now, they wanted that stricken from the record because they were basically calling it a narrative. It was his story. The judge has been reviewing all of the facts, and what he decided to do is this. He decided to take Justin Baldoni's amended complaint and act like it's the truth. Now, as you know, it is just his narrative. It's his story, his version of what things happened. But for the motion to dismiss, the judge decided that he would view this as if it was all facts. Now, in doing so, he decided that all of the motions to dismiss are granted, and I'm going to tell you why. He also decided that Exhibit A would not be stricken from the record. That's the timeline. And he said the reason he wasn't going to strike it is because, yes, it was redundant, extremely long, and in a narrative form, but he said it wasn't so redundant that he had to cancel it completely from the court records. So what he chose to do instead is, for the purpose of this dismissal, he chose to ignore it. So he did not use it or review it for the purpose of this dismissal. He also denied their application for their fees, their attorney fees, their damages, their punitive damages, but he refused that without prejudice, which means that they can refile it again at a later date, and I will tell you also why he did that. So buckle in, because there is a lot to go through, but it is extremely interesting what this judge had to say, and I'm going to try and break it down for you so it makes sense. The first thing the judge wanted to make extremely clear is this. He wanted everyone to know that what he's about to write, what we are going to read, does not reflect anything with the court. It does not reflect any of his opinions or his thoughts. All it is it simply repeats the account of events stated by the Wayfair party. So again, he's looking at the whole thing as if it's facts, and he's going to make his judgment based on that. The first thing he talked about was Justin Baldoni's timeline. Now, we know from previous sessions in court, he was not a fan of this timeline. He did not like how it was written, and he basically just called it a narrative or his story. He said the court does not consider this timeline in their decision because of this. It was written incorrectly for federal court. He said that it's supposed to be written basically in bullet form. It should be concise, and he said not buried in 170 pages of exhibits. He had no time to go through all of this, and he went on to say that their actual complaint was already 224 pages long, so this timeline was just a summary of everything that was already in the complaint. The next thing the judge did is he went through Justin Baldoni's amended complaint, and he summarized every single thing that Justin claimed in his documents, and he wrote it in such a concise and clear way that it was so much easier to get through. Now, if you want me to share this at a later date, just let me know in the comments, and I will do a video reading all of this. But for this purpose, I'm going to skip through all of that, assuming you know what Justin was accusing Blake and the team of already, and just get to the results. The next section in the document is all of the dates that everything took place, when people filed motions, when the response to a motion was filed, etc. So I will skip that as well and assume most of you know the time span of this. So it has been the last 3 or 4 months that the judge has been going through everything in order to make this ruling. The judge then goes into how a lawsuit can survive a motion to dismiss. And he says that the complaint must include sufficient factual matter accepted as true. It cannot just contain labels and conclusions. It has to have further factual enhancement. And the reason for that is this. He says, to put it another way, the plausibility requirement is this. It calls for enough fact to raise a reasonable expectation that discovery, when everything comes out and they're all being interviewed, that this has to reveal actual evidence supported by the claims. Throughout this whole document, the judge makes it extremely clear that that was what this was lacking. It was lacking factual information, factual evidence to prove what these accusations were saying. Now, there were two main things that Justin Baldoni and his team were going after. The first one had to do with Blake Lively and her stealing the film from Justin, breaching contracts, things like that. The second claim had to do with the New York Times and Leslie Sloan and Ryan Reynolds defaming Justin Baldoni. So those were the two main claims, but the Baldoni team also filed for a few other things. They filed for breach of contract, tortious interference with contract or prospective economic advantage, and also promissory fraud. So the number one claim that he had was that Blake Lively had all of these threats to try and take over the movie. Now, this is what the judge said to this. He said the Wayfarer parties cannot recover for Lively's alleged actions to steal creative control of the film. It says, regardless of her actions, they do not constitute civil extortion under California law. He went on to say that they have not adequately alleged that Lively's threats were wrongful extortion rather than legally permissible hard bargaining or renegotiation of working conditions. He also noted that Wayfarer has not shown any proof that Lively's alleged extortion damaged them in any way. And for the second main claim that they had, which was the New York Times publishing Blake's complaint and apparently Ryan Reynolds and Leslie Sloan defaming him by making comments, the judge ruled that this is not defamation because Wayfarer has not proven that the New York Times, Leslie Sloan, or Ryan Reynolds didn't actually believe what they were saying. The judge specifically said this: the Wayfarer parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted these statements were true based on the information that was available to them. And for all the rest of the claims, the judge said this: the Wayfarer parties' additional claims have also failed and must be dismissed in its entirety. But the Wayfarer parties have leave to amend their claims for breach of implied covenant and tortious interference with contract, and I will go into why that is later on. Okay, let's get into the why of all this. So first of all, the judge noted that for civil extortion, the false light claims against Sloan and Reynolds are based essentially on the same allegations, as are the claims for tortious interference against Reynolds. Now, false light is this: it means someone has been portrayed in a false or misleading manner that is highly offensive to a reasonable person. But again, this is not false light because Sloan, Reynolds, and the New York Times all believe this actually happened. The first reason that Blake and her team wanted this whole thing dismissed is this: they said that the amended complaint should be dismissed without further analysis because it engages in impermissible group pleading and otherwise violates federal rules. So basically what they're saying is when Baldoni's team wrote this, they didn't write specifics about who did what. Instead, they wrote things like the Lively parties and the Wayfarer parties, which left everything up to questioning, and the judge agreed with this. They also listed that the complaint's length and tangents made it difficult to understand exactly what the facts were in this case and how to read things. Now, the judge also agreed with that, but he said the Wayfarer party's amended complaint is lengthy and repetitive and relies heavily on group pleading, but it is not so confusing or lacking in substance that dismissal is appropriate. So he said no, he would not dismiss based on just that. At this point, the judge did use this opportunity, in my opinion, to take a little jab at Brian Friedman and the whole legal team for how this was written. It sounds like, from what we're reading in this, that it was really poorly written and Baldoni's legal team should have known better. So they specifically said the court will not parse through the various allegations and documents to determine whether a claim could theoretically be stated. So they said they're not going to put all this effort into trying to piece through all of this lengthy document. And they also said that the Wayfarer parties have an obligation to identify the statements which harmed them rather than just gesturing at a document or category of statements and forcing the defendant to guess which ones are actionable. So now let's get into the claims. The Wayfarer party's first claim is for civil extortion against Lively, Reynolds, and Sloan. They included 5 things under the extortion claim. Number 1, Lively refused to return to production unless Wayfair agreed to her return to production demands, her list of demands. Number 2, Lively threatened to abandon her contractual obligation to promote the film or approve marketing unless Wayfair agreed to co-fund a screening of her version of the film. Number 3, Lively threatened to boycott the premiere unless Baldoni was excluded. And number 4, Lively and Reynolds threatened to attack Wayfair in the press if it did not take blame for the problems during the filming. And the last one was that Sloan carried out Lively and Reynolds' threats by spreading false allegations that the Wayfair parties had engaged in or concealed sexual misconduct. So Lively, Reynolds, and Sloan all argued that none of these alleged acts are wrongful and that they did not obtain money or property from the Wayfair parties, and the judge agreed. He said that their argument was better, and he ruled it out. The judge said even if all 5 of these claims were true, it would nonetheless still fail because the Wayfair parties have not pleaded that any of this, giving control of the script, etc., led to any damages to Wayfair or Justin Baldoni. The judge also noted that Blake's team and Justin's team viewed what civil extortion was very differently, and he said Blake's team was correct. Their argument was right, and it requires actual damages in order to file for civil extortion, and Wayfair had no damages due to Blake's actions. He said in order to state a civil extortion claim, the plaintiff must allege that they suffered damages or lost something of value as a result of the defendant's threats. The threat alone is not sufficient. The judge said for the 4th claim, in that Blake and Ryan wanted Wayfair to take blame or credit for the problems during filming, he said that this is not actionable because Wayfair did not go through with this threat. They didn't take any blame, and therefore they didn't lose anything. He noted that Wayfair failed to plead that any of this caused them any monetary loss, and also they did not plead sufficient facts to support an inference that these threats were even legally wrongful. He said Lively didn't threaten any physical harm to any property or any people, nor did she threaten a false lawsuit. Wayfair's claims don't even focus on anything that Blake is threatening to do, but instead what Blake was threatening not to do. It said the Wayfair parties do not allege facts showing that Lively had an obligation to even promote the film or to approve marketing materials. They do not point to any contractual provisions, explain what Lively's contractual obligations even were, or even explain what contract is being referenced. In fact, numerous times in their complaint, they go on to say that Lively didn't even sign contracts. He said Wayfair hadn't even alleged that Lively had a contract to do the premiere with Baldoni in the first place, and a refusal to provide that which is not an obligation or under contract is not a threat. He noted it's a bargaining position. Bottom line, he says that everything included in here is insufficient to plead that Lively threatened to breach her contract. A complaint for breach of contract must include the contract itself, or at least plead its essential terms, and it was nothing. They didn't include anything about a contract. He also noted at the bottom here, the complaint emphasizes in several places that Lively had not signed relevant employment contracts and never explains what contract Lively even did sign. As for their claim of emotional duress, he says the facts in this alleged do not support an economic duress claim. The refusal to act in or market It Ends With Us is not an independent tort or crime. He noted that the only apparent loss to Wayfair in all of this was the hiring of an additional producer that Blake had in her return to work contract. And he pointed out in this that that was to better her work environment, and she got no gain, no monetary gain from this. So this does not fall under any of this either. He also noted that if an employer concedes to these requests, they cannot come back later and claim to be a victim of the employee's wrongful threats. So them agreeing to do this for Blake, they can't come back now and claim they're a victim. As for Blake threatening that she will not promote the movie unless they let her release her cut of the film, the judge noted that these demands do not involve a disproportionate exchange of value because Lively was going to do this for free. She was not asking for any additional pay to be more involved. It's also important that the judge noted at the bottom that at no point did Blake Lively ever threaten to reveal the sexual harassment aspect of what she was dealing with if her demands were not met. It's noted again that Wayfair did not provide any evidence that Blake Lively had a contractual obligation to promote the film. So the judge notes and said, this is just a fair trade for the Wayfair party's willingness to use her cut then. It's a fair trade. If she's not under contract, they were trading for her to do something to receive something else. Wayfair has also talked a lot about the fact that they claim Blake was forcing them to give her a producer credit or a PGA mark. The judge noted in this saying they also allege that Lively took over significant production responsibilities. So how can they say that she didn't deserve this when they're claiming she did all this extra work? He also noted something we've been saying for months. The amended complaint is not clear whether Wayfair or Sony had the ultimate right to choose the cut of the film. But he's saying if it's the case that it's Sony, which he believes it is because it's noted that the marketing plan was from Sony, he says then Lively would not have been withholding anything from the Wayfair parties that the Wayfair parties had a right to obtain from her in the first place. It would have been Sony's. He said, although the Wayfair parties state that Baldoni was forced to choose between killing the film and his own career by insisting on his own cut or his own creative version or going along with Blake's threats, it is noted here, filming was already complete. The judge said, this is false. Filming was done. Blake's job was over. He notes that the only loss in this case would have been Blake refusing to promote the film. He also notes that Wayfair could have sued Blake at any time if they didn't like what she was threatening or doing, but for good business reasons, they elected not to do so. He says Wayfair can't come back now and try and seek to recover damages for what they would have obtained had they not have agreed with Blake. He says the Wayfair party at no time in this alleged that Blake was under contract or was obligated to go to the premiere, let alone to go to the premiere with Justin Baldoni. And this was simply an agreement with them that Blake and Justin would do it separately. Blake's team alleges that Wayfair parties have not had any damages from any of these alleged threats from Blake. The judge agreed, and he said because of all of that we've just gone over is why he dismissed it, as well as the Wayfair parties have not alleged that Lively's editing or her involvement in the film at all in the production had any actual monetary loss or did any damage to the film. In fact, it may have done the opposite. He specifically says, although the Wayfair parties preferred Lively to take less of a role in the production of the film, they do not allege that it made less money due to her editing or that her role resulted in costs to them. Bottom line is Wayfair had the rights to It Ends With Us, and therefore they had the right to control what film would be produced and released based on the book. The judge even noted in here that any damages towards Justin Baldoni or Wayfair with Blake and Justin doing the separate premiere is just demeaning and humiliating, according to Wayfair. He said it's just a moral injury, as is giving Blake the PGA mark for being a producer on the film. So that brings us to the end of the civil extortion claims, and this is why the judge says it has now been dismissed. Now we have to get into the defamation claims, and they were brought against all parties involved. So defamation is this. Defamation constitutes an injury to reputation by a false, oral, or written communication. They are accusing a few things. So they are saying that these are the defamation statements, that the Wayfair parties engaged in, permitted, or failed to prevent sexually inappropriate conduct towards Lively. Number 2, the Wayfair parties retaliated against Lively and others for reporting this alleged sexual misconduct. And 3, that the Wayfair parties alleged that Lively, Sloan, and Reynolds all engaged in a conspiracy to spread these narratives to the Times and other media outlets, and that the Times committed defamation by publishing the same narratives. The judge right away, these allegations fail to state a defamation claim. Let's get into it. First of all, defamation, whether it's oral or written, has to be an injury to reputation, but truth is a complete defense to a defamation claim. If you believe it is true, it is not defamation. In order for a public figure like Justin Baldoni to prove libel or defamation, they also have to prove that there's malice involved, so that the person doesn't believe it's true and in fact knows it's not and is trying to harm them. The first thing the judge notes in this is this. The Wayfair parties have not adequately alleged a defamation claim as to any part of this purported conspiracy. The Wayfair parties have not adequately alleged that any false statements were made to the Times other than Blake Lively's statement, her complaint. They went on to say they have not adequately alleged that Sloan or Reynolds individually did any more than repeat Lively's version of events, and they have not adequately alleged that Lively should be held responsible for anything these two said. Their allegations of a conspiracy between the parties are none. They're not valid. He says one of the main hurdles in this is that the Wayfair parties don't know what Lively's parties and the New York Times communicated to each other. Now, they have lots of accusations, but it says that they failed to allege any facts regarding who said what, if anything, to the New York Times and when. A plaintiff who is unable to plead facts must, at a minimum, be able to plead circumstantial facts that support a plausible inference, that support your claims. They said that this has no factual allegations pleaded in this amended complaint, so it therefore does not state a claim. The judge did note that there is powerful inference that the Times had access to the complaint well before the date, but then he notes it doesn't matter. Blake is allowed to give her complaint to the media as long as she is doing it out of good faith. It's a fair report clause. It says the fair report privilege applies to Lively providing the complaint to the Times because it is a communication of statements that would be in the courts and the courts is public. It says a party need not wait until a legal document is formally filed before providing it to members of the press. So everybody online that was trying to find the dates and the timestamps and everything else of when Blake and the New York Times were talking, it was useless. It didn't matter anyway. She was allowed to give it to them at any time, as long as she meant to follow through and file it. The judge notes that there is no basis to infer anything other than that Blake's team was doing this out of good faith and contemplated seriously the filing of this complaint, which she did. She filed the CRD complaint within months of the events described in the complaint, and not long after it was plausibly given to the Times. And then 11 days later, she filed the complaint again, filed it with the court, making the same allegations that she made in her complaint. One of the other things that the Wayfair team was claiming was that there were text messages and emails that weren't in the complaint that were given to the New York Times, and this is what the judge had to say about that. He said the Wayfair parties do not allege that any texts or emails that weren't included in the complaint and that were given to the Times were even defamatory. In fact, it says, on the contrary, the messages discussed in the article but not in the complaint are often supportive of Baldoni's narrative. And as for the New York Times or Blake Lively cutting and choosing what she was going to put in her complaint, the judge said this: a person is not required to file a balanced pleading before an agency or in court. She is permitted to marshal the facts to tell her side of a contested story. She didn't have to show his side. She had to show hers. And an adversary cannot invoke the law of defamation and defeat the privilege by contending that the allegations are untrue. So Justin could not come forward and say he had an issue with this because they left out an upside down smiley face when she only has to show her side of the story. It also noted that Wayfair and Baldoni were accusing the New York Times and Blake of also selectively editing messages, and it specifically says no facts were given to support this allegation. As for Lively, Reynolds, and Sloan being in a conspiracy and working together with the New York Times, it says Wayfair parties allege no facts to support these insinuations. They had no facts to prove any of this was true. As for the sexual assault comment by Leslie Sloan and the sexual predator statement by Ryan Reynolds, the judge again says that none of this is defamation because both parties believed that what they were saying was true. Leslie Sloan has always said she did not say anything about sexual assault, and it has now come out, as you know, that the reporter for the Daily Mail sworn in a statement to the judge that this did not happen, that at no time did she ever say this, and that he misspoke when speaking with the Wayfair parties and even told them that she had not said this at any time. Justin Baldoni alleges that Ryan Reynolds went up to their shared agent and went and said to him, get rid of Baldoni, he's a sexual predator. Well, the judge said there's no malice or defamation involved in this either because Ryan Reynolds legit believed this to be true. He also noted that, again, Wayfair did not provide any contracts to prove that Justin Baldoni was using this agency or that Ryan Reynolds was, or no facts that this actually was said at all. And you may know from the past that the actual agent came out and said, Ryan Reynolds never said this to them. So they actually deny this even happened. Moving on to the New York Times defamation case that Justin Baldoni says they defamed him, the judge ruled that it is not defamation. They were simply publishing Blake Lively's complaint. They said it is clearly marked as the complaints in Lively's legal filing and are privileged as a fair and true report of that filing. As for the New York Times talking about the smear campaign, the judge says that the article states both that the campaign is alleged in Lively's legal complaint and also that the text messages show that it did in fact occur. In response to this, the Times argued that the messages contained in the article and also in Blake's complaint actually show that the Wayfarer parties did in fact engage in a smear campaign and that Wayfarer doesn't even dispute these messages. The judge said this: the complaint and the article contain numerous messages and documents strongly suggesting that Wayfarer parties did in fact spread negative stories about Blake Lively. A reader of those messages would have little doubt that the Wayfarer parties engaged in a smear campaign. This might be one of the most interesting pieces I read in this whole document. The judge noted this: some messages relied on the Wayfarer parties for the claim that they were not engaging in negative messaging regarding Lively and Reynolds can in fact be read to imply the opposite. A message from Baldoni to Nathan about protecting myself asks this: so do we say Blake and Ryan hired Harvey Weinstein's publicist? To which Nathan responds saying, that's a conversation I'm going to have with Jen and Jamie today. I remember this article. This was actually published. Now, the judge says this: this implies that Baldoni and Nathan at least considered spreading a negative story regarding Lively's choice of Sloan as her publicist. In addition, the Wayfarer parties emphasized texts between tag team members stating, we didn't tell Jed to go after the idea that her promo was inappropriate. That happened organically. The judge says this: but these texts can be read to imply that Tag did tell Wallace to go after Lively on other issues. If Wallace never spread anything negative about Lively, it is unclear why Tag members then would feel the need to note that Wallace did not spread this particular piece of negative publicity about Lively. And the judge finished it off with the New York Times part saying this: given the strength of the evidence in favor of a smear campaign, it is not plausible that the Times entered into serious doubts as to the truth of the smear campaign narrative as a whole, even if, for whatever reason, it misrepresented one particular set of messages in aid of that narrative. As for Baldoni's claim of false light, the judge notes and says the Wayfarer parties cannot benefit by simply relabeling their defamation claim as false light. They had the same things listed in both, and the judge said, it's gone, it's tossed. We're now moving into breach of implied covenant of good faith against Lively and why this was thrown out. This has to do with contracts, and the judge specifically says this: the Wayfarer parties' breach of implied covenant allegations are no good. The Wayfarer parties do not plead the terms of a relevant contract. They did not list contracts in this for Blake for anything. In fact, numerous times in their complaint, they said that she didn't even sign certain contracts. It goes on to say that the complaint actually contains vague references to contract negotiations or entitlements, but it also indicates several times that Lively did not sign her employment contract for the film. Therefore, it's dismissed. Next on the list was tortious interference with contractual relations or prospective economic advantage. So this is the Wayfarer parties alleging that Lively and Reynolds went up to a WME agent and told them to drop Justin Baldoni from their agency. Now, it goes on to say again that there are no contractual relations in this to be mentioned. So in order for him to make a decision on this, it would have had to list that Justin Baldoni had contracts with this company and that Blake and Ryan did as well. The judge says the Wayfarer parties failed to allege facts regarding their relationship with WME to support any of these torts. It went on to say that the Wayfarer parties do not allege that they had a contract with this company that was breached by Reynolds, knowingly or unknowingly. They also failed to allege that WME was influenced by Ryan Reynolds' statement in any way. The judge ruled that this is fatal to all three claims because there is no claim in the absence of facts showing that the relevant economic relationship even existed or was disrupted. As for the claim of promissory fraud and breach of implied contract against the New York Times, it specifically says these claims are meritless and they dumped it. It said there was no contract between Wayfair and New York Times. It says the Wayfair parties have not pleaded the existence of a contract, and making an email and saying that they want a response does not make a contract. Now for the final ruling. The judge said, when a motion to dismiss is granted, the usual practice is to grant leave to amend the complaint for whatever was missing. However, it is well established that leave to amend a complaint need not be granted when amendment would be futile. The court will not grant leave to amend the majority of the Wayfair parties' claims because amendment would be futile. The Wayfair parties do not identify any particular factual allegations that could be added to support the defamation or civil extortion claims, nor is it plausible that any allegations not yet mentioned would change the basic substance of Lively's threats, the conclusion that the complaint was privileged, or the conclusion that relevant statements were made without actual malice. However, here's the amendment part. The court will grant leave to amend the claims for tortious interference with contract and breach of implied contract. And the judge goes on to say it's because they did not provide any evidence of contracts. So if they do have contracts, he will allow an amendment and then decide if he will dismiss or not. Now, as for Blake and all the parties asking for motion for fees, this is why it was turned down. He says the court denies this motion without prejudice. That means they can refile to renewal in accordance with the ruling here because it's lacking further factual development. So he cannot rule that they are going to get their legal fees, etc., until he figures out if Brian Friedman, Justin Baldoni's lawyer, is going to refile with the actual contracts for those two claims. The judge ended this off by saying, the motions to dismiss are granted. The Wayfair parties have leave to file a second amend complaint by June 23rd, amending only the allegations relevant to the claims of tortious interference with contract and breach of implied covenant. The motions to strike the timeline is denied. The motions for fees and damages is denied without prejudice to renewal by formal motion. That is it. That is going through all 132 pages of what the judge said. At no point in there did the judge ever say the only reason he's dismissing this is because her claims were protected under California law. He basically said Wayfair had no evidence to what they were claiming. They did not include contracts, and therefore it's all dismissed. Drop your questions in the comments and I will try and answer them based on what I read through the documents. And if you do want me to make a video going through all of his allegations that the judge summed up, let me know in the comments and I will try and do that as well. As for now, Justin did file a motion to dismiss Blake's claims, but the judge has not yet ruled on that. If he does not dismiss her claims, we are going to court March of 2026 to see what exactly is going to happen between Blake and Justin when it goes in front of the judge.